Good morning, everyone. My name is Danielle S. Lewis, and I am the chairperson for the Economic Empowerment Systemomics Committee for the National Coalition of 100 Black Women Incorporated, Metropolitan Baton Rouge Chapter. And we would like to welcome you to our final event of our four-part series on building generational wealth through entrepreneurship. And we hope that you definitely enjoy all the information that is getting ready to be presented to you on today. Some housekeeping rules before we get started. We ask that you remain on mute, that you place questions in the chat box as they will be answered during the Q&A section. Stay engaged by answering polling questions and answer the brief survey at the end of the event. Our moderators for today are myself, Danielle S. Lewis, and Coalition Sister Diana Riley. And now please join me as we welcome the first Vice President of the National Coalition 100 Black Women Metropolitan Baton Rouge Chapter, Madam Dinesh Piper, as she shares the vision and the purpose of the National Coalition 100 Black Women Incorporated.
Thank you, Sister Lewis. The purpose of the National Coalition of 100 Black Women Incorporated is to foster principles of equal rights and opportunities, to promote the awareness of Black culture, to develop the potential of the membership for effective leadership and participation in civic affairs, to take action on specific issues of national and international importance, and to collaborate with other persons and organizations to achieve mutual goals. The vision of the National Coalition of 100 Black Women Incorporated is to see Black women and girls live in a world where socioeconomic inequity does not exist. The mission of the coalition is to advocate on behalf of Black women and girls and to promote leadership, development, and gender equity in the areas of health, education, and economic empowerment. At this point, I'll pass it back to our chair, Sister Lewis. You are on mute, Sister Lewis.
Thank you. I was all into it too. What is the Economic Empowerment Systemomics Committee? Well, the Coalition of 100 Black Women's economic programs focus on financial literacy, family wealth building, and entrepreneurship. Systemomics program is a philosophical mindset to consider ourselves first in all economic decisions. Our primary focuses are on pay equity, African-American women-owned business growth, and livable wage employment opportunities. Now, I have the opportunity and the pleasure of welcoming our first presenter, Kimberly Hardy Lamont. Kimberly Hardy Lamont earned her Juris Doctor degree from Southern University Law Center in Baton Rouge, Louisiana, and was admitted into the Louisiana Bar in 2012. After working with the Louisiana House of Representatives and the Louisiana Department of Health, she returned to the Law Center in 2017 as an academic counselor, instructor of law. She also serves as the director of the Board of Student Advisors and co-director of the Summer Pre-Law Program. Professor Lamont earned both Bachelor of Science in Pharmacy and Doctor of Pharmacy degrees from Xavier University of Louisiana College of Pharmacy. Her pharmacy practice experience includes retail, hospital, and clinical pharmacy, as well as positions in pharmacy administration. Professor Lamont is a licensed pharmacist in Louisiana and is currently a member of the American Bar Association, Louisiana Bar Association, and has served as a continuing pharmacy education presenter for the Louisiana Pharmacists Association. Being passionate about the local community, Professor Lamont is currently a member of Delta Sigma Theta Sorority Incorporated and the Links Incorporated. She is also a sustaining member of the Junior League of Baton Rouge and an associate member of Jack and Jill of America Incorporated. Professor Lamont serves as a member of the Diversity, Equity, Inclusion Board Committee of Episcopal High School of Baton Rouge and a volunteer mentor at Baton Rouge Youth Coalition. I now turn the mic over to Attorney Kimberly Hardy Lamont.
Well, thank you so very much, Ms. Lewis. I appreciate that introduction. Want to first of all make sure everyone can hear me fine. If I can get a thumbs up, that's great. Okay, fabulous. Thank you so very much. And good morning. Good morning to the women of the National Coalition of 100 Black Women of Metro Baton Rouge. And I would like to thank, first of all, your chapter president, Ms. Courtney Hunt, who I'm glad to say that she is a sorority sister of mine in Delta Sigma Theta Sorority Incorporated. I'd also like to thank you for the opportunity to present along with my supervisor from work, Professor AVC Reed, who will be coming behind me in a second. And thank you to all the participants, of course, who they are joining us as we are progressing through today's program. As Ms. Lewis stated, my name is Kimberly Lamont. I'm a member of Kappa Chapter of the Links Incorporated, located here in Baton Rouge. I would like to, first of all, be sure to bring welcome from my chapter president from Kappa Tau, who is Dr. Sunsari O'Rourke Allen, who is not able to be with us right now because some of you may know she is a practicing dentist in the local community. So she is probably knee deep in doing something for someone that they really need to have done today. So, but I am very excited to share some information with you on a program that we have, National Trends and Services. So if I can, I'm going to stop that share and I'm going to share my screen. Okay. Here we go. Can everybody see that? Let me put it on. There we go. Okay. Hopefully everyone can see that. So today's presentation will begin with a very short, I promise, a very short history of the Links Incorporated, specifically the National Trends and Services facet. And then we will move to the issue of heirs property, present some statistics and information on the issue, discuss local impacts of heirs property, and then offer some solutions and identify a few resources to help address the issue. So those of you who are attorneys on the call know that first thing I want to do is give a disclaimer. This information is intended strictly for educational purposes. It is not offered as legal advice. Further, this presentation does not establish an attorney-client relationship between the presenter and any of the participants. And you are urged and advised to seek legal counsel for appropriate direction specific to your situation. Okay, given that out the way, everybody knows, the attorneys know we worked hard for that bar roll number, so I don't want anything to jeopardize it. So the Links Incorporated, who are we? The Links Incorporated is one of the nation's oldest and largest volunteer service organizations of extraordinary women who are committed to enriching, sustaining, and ensuring the culture and economic survival of African Americans and other persons of African ancestry. A few of our honorary members, we don't have many, but a few of our honorary members include Leontine Price, Rosa Parks, and Vice President Kamala Harris. The outstanding programming of the Links Incorporated has 5 facets, which include services to youth, the arts, national trends and services, international trends and services, and health and human services as well. Of note is that Links members contribute more than 1 million documented hours of community service annually. And I would probably say that we probably match that in undocumented hours of service as well. So specifically with National Trends and Services, programming, it sounds similar to what Ms. Lewis just described, which is why we're here today. And I saw in your mission, you mentioned that you'd like to connect and partner with like-minded organizations. And it sounds as if we have certainly done that today. National Trends and Services, which we call NTS programming, addresses the social inequalities that persist in Black communities throughout the United States. And we are just committed to raising awareness on the economic, health, social justice, and barriers to successful living here. So why are we here today? We are here today to hear about a program called Healthy Homestead, which addresses the issue of heirs property. So one thing that I did want to do is I want to stop the share for a second, and I want to launch a quick little poll. I want to know how many of our participants today have a current will. Hopefully everyone can see the poll. I want to know how many people here right now have a current valid will. And just a few more people to, okay. Just a few more seconds. Just a quick one question poll. Okay. All right. Well, here we go. 5 people do not, most people do not. Only 2 do have a current will in place. I would say that that is probably par for the course. What we have here. One other question while we're polling. Do you know what the current issues, do you know the current issue with heir property? Have you ever heard of it? Are you familiar with it? Have you experienced it? And the reason why I ask, because heirs property has been described as the worst problem that you have never heard of. Okay, but guess what? We have more people who have heard about it than who have not. That's interesting. Okay, want to share that real quick. 4 have said that they did, and 3 have said that they did not. Okay, well, let's get back to sharing, and we're going to get into this. I see you, Rashana. Okay, so pivoting back to our Southern Area Initiative with the Links Incorporated Healthy Homestead. The problem that needs to be addressed is one that unfortunately is a long-standing issue in our community, and it continues to plague our community, frankly. African Americans are disadvantaged by significant racial gaps in wage and wealth, home ownership. And this gap is the result of many factors, a lack of financial information and knowledge, difference in earnings, lack of confidence in financial institutions. That is something that is pretty significant in our communities, and home and business ownership gaps, just to name a few. According to the Samuel Du Bois Cook Center on Social Equity, Black households hold less than 7 cents on the dollar as compared to white households, less than 7 cents compared to white households. And while the 99th percentile Black family is worth 1.6 million, the 99th percentile white family is worth over 12 million. So those are some pretty astounding numbers. But this one stat that I have up here now is one that completely blows me away. 80% of land owned by Blacks has been lost since 1910 due to heirs property. More than 80% of the land. We have only retained 20% of our land since 1910. And that is solely due to heirs property. And this is a statistic from the actually the US Census Bureau and the US Department of Agriculture. So I've mentioned heirs property a few times. So let's add a little bit of context to that term. Heirs property is defined as property that is passed down informally from generation to generation. And the key word there is informally. In most cases, this occurs because the landowner dies without a will, and no one has open succession to be sure to dispense the person's assets to where they need to be. One thing of note is when someone dies without a will, when they have not stipulated exactly how they want their assets to be distributed to whoever, the state of Louisiana makes that determination. And that is called intestate succession. So one thing we definitely want to do is make sure that people leave here and make sure that they leave their assets with exactly who they want to have their assets. Okay. This results in distant relatives who could virtually be strangers becoming co-owners of property. Okay. So let's walk through a quick little simple common hypothetical situation. So a woman meets a man. They have 2 kids together, a son and a daughter. Nice little nuclear family. Or so we think. They purchase a home together. Okay, that's fine. Then they break up and dad leaves. Okay. He's gone out the picture. A few years later, mother passes away. Then her son has some children on his own. And then he decides to move back into the family home, the home that he was raised in. Okay. So then he actually, the daughter has some children as well. Okay. The son even becomes a grandfather. He has his first little granddaughter. Okay. So we have the mother who is deceased. The son is living in the house. And then one of his daughters moves into the house to help take care of him because he's getting up in age now and he needs somebody to help take care of him. Okay. He passes away. The daughter, just totally stressed out, it's too much. She passes away. So what we have here now is we have a granddaughter who is living in the house, probably the house that she may have been born in, that she certainly was raised in. Her father was raised in. This is her grandmother's property, right? Okay. So she's thinking that this is her house, right? This is what she's thinking. And it makes sense. Intuitively, that makes sense. But because the son and the daughter never opened succession on the mother's property, we have what we then call heirs property. Who is the legal owner of the home? The mother. The deceased mother is still the record owner of the property, even though it has gone through the son and the daughter, and now the granddaughter is in possession of the property. And all of these grandchildren and great-grandchildren have varying degrees of ownership interests in the house. And let's not forget this. Remember, dad's still out there, okay? And remember, they had purchased this home together. So father's still out there and he has an ownership interest in this house. And God only knows how many children dad has had since he left out the picture, right? So at this point, we have a whole lot of people, a whole lot of confusion to sift through to determine how many people have an ownership interest in mother's property that she co-owned with father, okay? So, this situation happens far too frequently. And families lack the knowledge and frankly, the resource to go through succession, because succession can be a long process and an expensive process. And to a lot of people, it just does not make good financial sense to do this. It's like, wait, what do I have to do? I'm already in the house. I have the house. I'm paying the taxes. I'm keeping it up. Why is it that I have to do this to own a home that I'm already living in? So, and as I said, that may make sense initially until there are several generations of distant relatives that could possibly have an ownership interest in the home. And these relatives may not even know each other. Clearly, the people, the purpose up here, they're not going to know the great-granddaughter. They're not going to know the grandson. So they don't have any sentimental attachment, any emotional attachment. To them, it is just, frankly, an asset that someone could easily offer them some money for. And then what happens? The grandsons, the granddaughters, the great-granddaughters find themselves in a co-ownership situation with someone who might be a developer who understands that, hey, this might be some property that they're interested in and that they find to be of value. So we've looked at this as a hypothetical situation. Let me see if I can share. Hold on, y'all, 1 second, because I have a quick little video. I promise it's quick. A quick little video I want to show you all from a family in North Louisiana who had this happen to them. Okay, hold on, I need to make sure I share audio as well. Hold on 1 second, share sound.
Under this structure. And so you're having a population sitting in this very vulnerable way, and oftentimes in a way that they don't understand how the law operates, sometimes until a lawsuit is filed.
But land been in our family for at least 120.
Hold on, let's see what
25 years. Started with my great-grandfather.
Do you love Gantt charts? Here's how easily you can build one in ClickUp.
But land is, for me, a lot of memories, part of my roots. I was proud of the name Lewis. We worked to have something. And I guess, for say, we lost it.
The Lewis family owned 480 acres of land and a homestead in northern Louisiana. Because the land was heirs' property, several distant family members were able to sell their share of it to a local timber developer named James Tuggle. Tuggle forced the sale of the land that happened last year.
My great-great-grandfather raised 13 kids where that house sits. I mean, there are so many heirs tied into the Lewis properties. It'll make your head spin. Taxes were always paid on time. We were under the impression that could no one person from the family just up and sell any part of the property without anyone being notified.
Do you all know the relatives that sold their part?
I've only seen one once.
You in New York, wherever, going on with your life, you don't really know nothing about this little country spot right here. You don't know nothing about this here.
As part of the legal process, the forced sale of heirs' property has to be publicly announced. In the Lewis's situation, a local newspaper posted a notice in the weeks leading up to the auction.
This is a small town. Okay, this is not like the Washington Post or New York Journal or whatever, you know. There's no paper out here in the country that's being delivered to the doorstep. You know, ain't no ball riding no bicycle throwing no paper on the front porch down here. So walk in and just do a family like that. I don't understand that. My mama keep the insurance on this house. She keep a roof on this house. She keep these bills paid on this house. You know, my thing is, your house has been here for years. Because of technicality, you uprooted a family.
Shortly after James Tuggle completed the purchase of the Lewis property last year, the sheriff evicted Michael.
So this is where your
trailer was sitting here. Those are the steps to the front entrance. I called the sheriff. Well, it's his property. He can do with what he wants.
The sheriff saying that Tuggle could do what he wants.
He can do what he wants. It's his property. I suggest you move the trailer. He says, well, that's all I can tell you. Is there anything I can help you with? I told him no.
Michael ended up with a little over $2,800 for his share of the property. He used it to relocate his trailer home to a half-acre lot nearby.
Still got to put in a water line. The water line's across the road. I could be angry to the point that I want to do something to somebody. I mean, you're talking about 125 years of family heritage.
Michael invited us in to see the documents from the local.
Okay. I said that it was going to be short, but I will be sure to share the link to this. Again, over 125 years of family history, 480, I think over 480 acres. And he got less than $3,000. And it's really, it does not seem that like it's about the money. It's the principle of it. And when we think about the money, the land is generational wealth. 480 acres, that's generational wealth. That is a game changer, not for just him, but for generations to come. So this is exactly what happened. I think they said the man's name was Mr. Tuggle. He said, that's some good land. Let me see what I can do. And if you have all the, 70 heirs, and again, New York all over the place, they're not tied to that land like those two gentlemen were. So yeah, they'll take a couple of hundred, a couple of thousand, knowing that that is probably hundreds of thousands of dollars of land, and then force a sale. It's sad. But that is one of the, like I said, we went through our hypothetical, but I wanted to share that real life situation, especially one here in Louisiana. This issue is not specific to Louisiana. This is throughout the country. This is throughout the country. And by and large, when we think property, most of our minds immediately go to residential property, but our people had acres of agricultural land that this has been, this is the method by which we have been disinvested of our property. Okay, let me get back to my thing. So before I preach a whole incomplete sermon to y'all. Okay. All right, so what are the problems? Let's go back to our hypothetical that we had. What are some of the problems that the granddaughter will have now that she's trying to understand what is going on with this property, mother's property? So the granddaughter is going to need unanimous consent of all those owners, even those purple people, even the purple people. She's going to need unanimous consent of all owners for any major decisions or alterations to the property. She certainly can't sell it without their consent. And she probably won't be able to get them to agree. She probably won't be able to get in touch with all of them even. Payment of taxes. Taxes usually fall to one person. One person usually steps up to pay the taxes. Or they do this, round robin. Okay, I'm gonna pay it this year, you pay it next year, so-and-so, because, Junebug gonna pay it the following year, cousin, all that. And that usually works for a certain amount of time until they realize that based upon the assessed value of the home, people are paying different amounts of taxes, that's going to change. And paying taxes does not equal ownership. Paying taxes does not equal ownership. What paying taxes would allow you to do is maybe get a reimbursement at the end. They'll say, okay, well, this person gets credit because they paid the taxes in 2017, 2019, and 2021. Give us your tax receipt and you'll get a reimbursement for that. Eligibility for federal funds. Only the record owner is able to receive funds for that home, because that is the person who is the legal owner of the house. And if that person is deceased, we have an issue. And we're going to come back to that specifically about federal funds. The house cannot be used, the property cannot be used as security or collateral, because that is something that would require everyone's consent. The marketability of the home. Who would want to purchase a home? Well, first of all, there's no clear title to the home. So who is selling it? That is not clear. Excuse me. And who would want to try to purchase this home from all these different people? Talk about chaos and confusion. And then, of course, as we discussed, there's a risk of a forced sale. So just as would happen in the video, if there is a developer, even a speculative developer realizes that the property either sits on a nice piece of land or situated such that, oh, there's a subdivision coming up or something like that. And they may approach one of those distant heirs to purchase their interest in the home. And then that developer is then co-owner in a co-ownership situation with these grandchildren, great-grandchildren, these half siblings and cousins and all of this. I said to put a pin by the federal funds because heirs property, the issue of heirs property, as horrible as it already is, it is magnified in the instance of damage to homes. And we know, as we sit here now, we just chatted about, we're expecting yet another downpour today. We know we just recently last year had Hurricane Ida. 2016, we had the historic flood, which was an unnamed storm But this just magnifies the impact, the negative impact of heirs property. We know how susceptible we are in South Louisiana. We have hurricanes, flooding, and now we even have tornadoes. Now we even have tornadoes that we need to be concerned about. So heirs property was a huge issue in the historic flood of 2016, as well as Hurricane Katrina as well. In both cases, there were individuals that were living in homes, just like the granddaughter would have been, that they were not the legal owner of. So then here comes, it didn't take much. I don't have to say 5 feet of water. It could have been 5 inches of water. We know people who were out of their homes for a year behind literally 5 inches of water. But they were unable to qualify for and receive aid to rebuild their homes because they're not the record owner. FEMA denied aid to more than 2,500 homes in disaster declared parishes who couldn't prove home ownership after the 2016 flood in Baton Rouge, 2,500 homes. And with Hurricane Katrina damaged over 70% of the housing units in the city of New Orleans. That's the vast majority of the city. And 15% of the applications that went to the Road Home program were denied or delayed or something due to heirs property, people living in the house, but they cannot prove that they are the record owner. And ladies, to bring this issue even closer to home, African-American homes are by and large headed by single women. Single African-American women are usually the head of households for African-American homes. So we are disproportionately impacted by this. So, you know, it's interesting, these 2 pictures, this one is of Baton Rouge, the next one is of Katrina. They look almost identical. So we've identified the issue, right? We've identified the problem. And that was one of our goals, was to identify the problem. So what do we do about it, right? What can we do about it? Well, one thing is if someone is already in this situation, like our hypothetical, or like the video clip that we just looked at, the only way to cure the situation is through succession. That is the only way that they can cure that. And usually that winds up being not just one person's succession, multiple people's successions. Estates have to be probated. And that is something that is costly and it is time consuming. There are some legal options that may make it a little bit less costly or time consuming based upon the initial value of the estate. But that is, again, something that you and your attorney need to discuss in consultation. But one of the things, if someone is not in that situation, a will may be able to be a tool to help prevent that issue from happening. And just quickly, because I want to be mindful of the time as well, we have in Louisiana, generally, we have 2 different types of wills. Olographic is handwritten by the deceased, and the notarial will is one that an attorney drafts and notarizes for the person. The person who's dispensing with their property is identified as a testator. The people who are inheriting the assets, they are not heirs, they are legatees. And the person who is going to handle the affairs will be the executor or executrix. So, you know, clearly with this legalese, we understand why this is something that an attorney should be involved in with the notarial wills. There are some resources that are available. I want to identify some community resources, certain nonprofits and other entities. Louisiana Appleseed is a fabulous resource. Appleseed is a network of nearly 20 different centers across the United States and Mexico. Our Louisiana Appleseed location is in New Orleans, Louisiana. After Hurricane Katrina and the 2016 flood, they were integral in having legislation pushed through that helped simplify the process of opening succession. I believe when it started, I believe that the upper value was $75,000, but I know that the current value is $125,000. If someone does have an estate that is $125,000 or less, there's a simplified process that they can go through succession by via affidavit. And it could really save people significant amount of money if they qualify for that. And of course, with Louisiana Appleseed, by being a nonprofit, you also have to income qualify for that. Southeast Louisiana Legal Services, another fabulous opportunity that people, again, you have to income qualify there. But Southeast Louisiana Legal Services offers civil legal services throughout more than 20 parishes in the state of Louisiana. They offer wills clinics throughout the year, and they also offer wills for heroes as well. So those people who have served in our armed forces, Southeast Louisiana Legal Services will draft a will for them free of charge. There's an heirs determination worksheet. I'm going to drop several of these resources in the chat as soon as I wrap up my presentation. The heirs determination worksheet, I want to note that this is a resource that comes from Georgia. It is the Georgia Heirs Property Law Center, but it is an excellent resource for keeping track of, it's an elaborate family tree for keeping track of the specific details that you need to have for all of these heirs. And also hot off the press is that Southern University Law Center is establishing an heirs property institute, and it's going to assist disadvantaged rural and urban. So the within the city, as well as at agricultural land as well, rural property, families in securing and solidifying their property rights. So with that, I want to revisit the goals that we set out at the very beginning. We said that we're going to be introduced to the Links Incorporated. We also introduced to the issue of heirs property, receive some statistics and information on the issue, discuss some of the local impacts of heirs property, and offer some preventative and curative solutions and provide resources to the issue. So I would like to thank you all for your time. I am going to drop an evaluation link in the chat if possible. If you can think about if we have accomplished those goals, I would appreciate you stating that on the evaluation. If not, hey, don't click that link. I'm just playing. We always want to try and improve. So if there's something that you think we can improve upon, certainly we welcome that feedback as well. And I will open it up for questions at this time.
Do we have any questions in the chat or on Facebook Live?
I am not showing any on Facebook Live, but I noticed one of our sisters in the chat sharing her personal Esquire experience, I'm believing. Sister Hunter, would you like to share that experience with the audience?
I'm so sorry. I'm being so obnoxious. I literally just messaged back that contrary to what I'm showing in the chat, I don't want to take over, but I do have a very interesting story. Okay, one of those places that Kimberly put up, Southeast Louisiana Legal Services, that's where I worked, where I did all those successions for the people who were getting FEMA denials. And it's very important to, now listen, I know family can be nuts, okay? I have a family, right? So I know that people can be crazy. And I have literally seen people argue with successions and wills and stuff over like pots and pans and forks because they were like sterling silver and they said Momo gave it to them. Okay, so you have to have conversations with them beforehand to avoid it. But I literally had several successions where the people, when it's time to name the heirs of the property, you can't because they didn't grow up in the same home and they don't know their siblings' real names. They know the name that they call them. And then I will say, I'm not saying that it's exclusive to us, but I only saw that with Black clients. And so I know that like, oh, I'm so sorry, Lord, this is live on Facebook, but okay, we family. So here's the thing. Y'all know that as a culture, we do not put things in writing. You know, we don't get wills. We don't think that we have anything to give away. Put everything down, because what you don't put down, then the state puts a value on it and distributes it, you know, if you don't do it yourself. And so again, it's important to go over your family tree. And I know it sounds like really remedial questions, but just to ask people what their legal full names are, because I can't put, Boo Boo and Ray Ray on a succession document, and then their portion, it can't be counted for. So that's just a long way of saying that seriously, you're right, Courtney Hunt, we do need to educate our community on the importance of having wills and successions, and also the importance of knowing people's addresses, telephone numbers, ways to contact them, because you need that information when you're putting the property in the right people's hands. The end. I'm done.
And that's what that heirs determination worksheet does. It's really a great, it's a fillable PDF, and it's really a great opportunity to collect all that information. What I suggest is that someone take that on in the family, and then keep it somewhere. Give the important people who need to have that information, give them copies of that, and make sure that everyone is aware that this is available, that this is what we need to we need to have, because there is going to come a day when you're going to need it, for sure. How can we normalize the conversation of will writing appears in our culture? This is a very sensitive topic. We equate wills to death. Yes, absolutely. And let me say this, having had my will drafted, y'all, I was just like, we got down to, because it was a somewhat complex will, and it shook me. It shook me. And, my children were young. And so in the event that you and your husband pass away at the same time, who would you like to have custody of your children? I was like, wait, I need a minute. I need a minute. But it is something that people do. It's necessary. It is absolutely necessary. Most attorneys do have worksheets that they will send home with the client. So that kind of helps the client be able to do it a little bit at a time, as opposed to feeling almost blindsided in an office where you're asking all these questions. And it's like, wait, you need a minute to think about those things, to consider those things. But it is absolutely something. And I know a lot of families utilize the opportunity when there's a family funeral to say, okay, y'all, we need to make sure everybody needs to have their papers in order, their business in order. Everybody needs to, designate someone in the family to know some things and to have copies of some things.
I have a question.
Yeah.
I'm sorry. I think I'm echoing because of my double computer.
No problem.
How important is it for only child to have that?
Well, I'll tell you this. Ask someone who thinks that they're the only child until mom or dad passes away. That's the one thing. It's absolutely, everyone needs a will. That's my opinion. Everyone needs a will.
It sounds like we need a wills clinic.
Yep. Absolutely.
I will agree with Kimberly on her last statement when she says when there's death, because I know when my father died, my parents only had 4 children that we knew about. However, at death, there were 4 more that showed up at the funeral.
You never know.
You never ever know.
You never know. And just like in the hypothetical, the purple children, you can best believe they're never even driven past the house. But guess what? Once the money hits the table, everybody comes. So heirs property has been described as the biggest problem that you've never heard of. And it has these, it just travels. You're talking about everybody has cousins in California, so cousins in California, the cousins in New York, everybody gets involved. And like Rashana said, you don't know people's, government names, and how can you name them in a will? So there's some significant legwork and effort that needs to be put in on the front end.
Well, thank you so much, Attorney Lamont. Do we have any other questions? I just want to thank Attorney Lamont, because as we talked while we were planning this event, I told you my personal experience with my great-grandmother's property in Plaquemines Parish, and the issue my mother had to go through because there was no will in place, no succession done. any of that. And my great grandmother had 10 children. And so we had a personal issue. So I know wholeheartedly how important this information that Attorney Lamont is sharing with you all. And the reason that we definitely need to get those wills in place and have a succession plan in place. So thank you so much, Attorney Lamont, for all of this great information. And please reach out to Attorney Lamont if you want to schedule. I know, do we have anything set up where we can get those wills and everything set up for individuals?
Let me put my email address here. I just dropped it in the chat, okay? And please, again, if you can, complete the evaluation. Please complete the evaluation.
Well, thank you again, Attorney Lamont. It is now time for me to introduce our next presenter, Attorney Cynthia Reed. Attorney Reed has been employed at the Law Center for over 22 years. She was named as a Director of Continuing Legal Education in July of 1999, and she served in that capacity until 2019, when she was appointed to the position of Associate Vice Chancellor of Academic Support and joined the full-time faculty as an Associate Professor of Law. Before joining Southern University Law Center, Attorney Reed was under the tutelage of now retired Judge Luke A. Laverne, who assisted her in starting her career in private practice in the area of family law and successions and donations. Attorney Reed also served as an Assistant Attorney General, working in the areas of civil litigation and workers' compensation. So I'm gonna pause really quickly. Attorney Reed, you know, I'm an insurance agent, so I don't know how that's going to work too well. But Attorney Reed is a member of the Louisiana State Bar Association, National Bar Association, National Bar Women's Lawyers Division, Baton Rouge Bar Association, the Greater Baton Rouge Chapter of the Louis A. Martinet Legal Services, Louisiana Supreme Court's MCLE Committee, American Bar Association, Baton Rouge Women Leaders Association, Alpha Kappa Alpha Sorority Incorporated, and the Top Ladies of Distinction. I now turn the mic over to Attorney Cynthia Reed.
Good morning, almost good afternoon. I am Cynthia Reed. Can everyone hear me? Okay. I want to also continue the disclaimer, as my colleague stated early on, that this is strictly for educational purposes and not as a client-attorney relationship. And I also want to thank the National Coalition of 100 Black Women, along with the president, for inviting me this evening. And before we started, I told them I was here till about 6 o'clock this morning, went home, slept for about a good 2 hours, and made it back. So hopefully you all will be engaging at the end and ask a couple of questions. And I spoke earlier about what Professor Lamont was talking about earlier about wills. And I always tell my clients something my mother always said to me: always take care of your business. Do not allow your business to take care of you. And at death, that's when it really, really starts. And the person that you assume the brightest one of the family is going to be the best one. Generally, that may be the worst one. So be careful in any and everything that you do. And I know Kimberly said, and someone asked the question, how do you start that conversation with your family? It's very hard to do because I know I did my grandmother's will all the way in Georgia. And people tend to think when you say, let me do a will, that means I'm about to die. That is not the case. You're just getting your business in order. And that's the best thing that you can do. So my presentation is basically on estate planning, which is generational wealth. How do we go about doing that? And definitely we need to start doing that. Okay, y'all can see my slides. Okay, let me move this out the way where everyone can see the slides. Okay. Okay, what is generational wealth? It is wealth that is passed down from one generation to the next. You may also hear this called family wealth or legacy wealth. And I generally speak to a lot of Black families, literally during the holidays. And it could be families from California, Virginia. They all just come together and they definitely want to know, how do we go about keeping things in the family? And with generational wealth, you definitely want to keep things by a trust versus a will, because a will is very limited, as opposed to a trust. You can do a whole lot of things in a trust that you can't do in a will. And a lot of people think that they're one and the same, and they really are not. So if you are able to leave something behind to, i.e., your children or grandchildren, then you are truly contributing to the growth of generational wealth in your family. And where does this wealth come from? It comes in various forms, such as real estate assets, stock market investments, or a financial education to carry forth in the future. And here is what I would call a generational wealth. Mom is in the middle, and there's daughter, and then there's the granddaughter. 3 generations. And this is what you think about when you're thinking about generational wealth. You always want to continue to pass it down to your family members and thereafter. Now, what are the best ways to prepare to leave a legacy of wealth behind for your child or your grandchildren? Again, invest in the stock market, invest in real estate, build a business that you are able to pass down. Take advantage of life insurance. And with life insurances, I will say most Black individuals do not put a high price tag of insurance on themselves. And I learned early on, oh my God, probably 40 years ago, when I was an undergrad, just listening to people, because one thing I will talk, but I can talk while the other one is talking also, but I'm still listening. And I tend to just soak up all that good information. And I started listening, and they would put 1, 2, 3. And I was also friends with a lot of the basketball players, the Black basketball players that went pro. And then when I moved here, I got to know someone, the same thing that was in the insurance business. And he would say, Cynthia, you need to put some insurance on yourself. I said, okay. And I'm single, no children. So who am I going to leave it to? Well, when my mother was alive, it was her. Then my dad went on to him, but now both of them are gone. So I now have my sister, and I know she'll take care of brother with a long handle spoon. Why do we do things? Because we have to ask ourselves, because my mom was a talker too, and she was going to teach me. All parents know about their children. They know who to put in charge and who not to put in charge. Why? Because if you don't, they all are going to be on the same page. And that's where the mess begins. So you put a nice price tag, because that's what the other people do. You could put that 2, 3 million, and they're going to use it, invest it in something else. This is something we do not do. Invest in your child's education. Now, what do I mean by that? If you're able, and I know some of you are, where your child will not have to pay any tuition costs, they have no financial aid, no loans, no student loans. And when they graduate, they can begin their investments also, because they don't have to worry about paying back the federal government or Fannie Mae back in my day. Teach your children about your personal finances. And this is something we don't discuss because we figure, oh, they're too young. That's not the case. I was watching television when I woke up this morning. They had 2 young girls that started at the age of 5 doing something with paper. And now one is about to go to college. The other one's going to the 10th grade. And an individual loved their idea and decided to invest in it at such a young age. Start your children with stocks, because that's when they are the most vulnerable. And they're just, I think I was a sponge back then when I was younger. Anything an adult said, I was wanting to learn. I would read anything they had given to me. So this would be a good time for you to do the same with your children. And they could become young entrepreneurs at such an early age also. Create multiple streams of income. And if you are self-employed, of course, pay yourself first. And these are some other steps in order for you to invest. Different examples would be with Vanguard, Merrill Edge, Merrill Lynch, E-Trade, which is stocks, bonds, Wall Street. And I know early on, I have a lot of, I call them my brothers in the law here, and they started doing investment, and all of us were playing golf. And I said, oh, I don't like running behind that little ball. And it was too hot out there for me. And I look at them now, they all are great investors. But I ended up investing with Southern, and my little stock is doing very well. But you don't have to do a lot. But over the years, it accumulates. It does accumulate. And you'll be like, oh my God, wow, I am doing well. But you never think about it because you can take out so much every month, you're not going to miss it. But we need to now start to thinking in that same manner. And this is how we build generational wealth. Again, invest in that stock market, invest in the real estate, build a business to pass it down, take advantage of your life insurance, invest in your child's education, and teach your children about the personal finance. Now, how do we go about doing all of this? It sounds good, but how do we do about it when we have no idea? The first thing you need to meet with someone, meet with a lawyer, meet with an investor, because one thing you need to do is to create an estate plan. Now, the question becomes, how do I know who's good and who's bad? That's one of the biggest questions when you're dealing with anything legal. You need to be able to ask that person questions. You know, how long have you been doing this? How many trusts have you prepared for individuals? You don't want to go to anyone that literally has no experience, because it's only going to hurt you in the end. You can also, as Kimberly said earlier, you can write a will. But again, wills are very limited. You can put a will in a trust also. And set up custodial accounts. And then name your beneficiaries. Now, one thing about life insurance, naming your beneficiaries, even with your 401ks and everything, that goes outside of the succession. It goes to the named beneficiary. So just remember that. Now, and this is a little quote that I thought I liked. Wealthy people plan for 3 generations, these beautiful homes. Other people plan for what are we going to be doing on Saturday night? So you have to say, which one are you? Are we only worried about that short term? What can we do? Where can we travel? But what are you putting aside for your children or your grandchildren, where you can make their lives a lot easier than your own? How to pass on that generational wealth. Here's that living trust and estate planning. When it comes down to the control you will have over your family's wealth and well-being after you are gone, an estate plan and a will are very essential. With these tools, you can set up your own kids, your grandkids, and future generations with the tools they need to handle the wealth that you have built. Now, what do I mean by, when I mentioned earlier, setting up custodial accounts? You don't have to wait to pass down wealth until you are generally gone. You can and should also set up custodial accounts for your children. A custodial account is an investment account that you manage on behalf of your child up until they reach a certain age. Typically, most families will do once that child reaches the age of 18 or 21. And you can also state maybe at the age of 18, they get so much money. And then after 21 and sometimes 35, they'll get the balance. These are great ways to set money aside for your child's future. The money can be used for college. It could be used for a starter home, or it could actually be used for them to start a business or any other financial goals you want to help your child meet his or her goal. And create an estate plan and will. If you can look at yourself and you say, I've worked hard to build this wealth, and I want it to go on to my child or my grandkids. So it's important for you to create that estate plan with a lawyer to truly outline your wishes, your desires. This plan will provide your relatives with instructions about how wealth should be handled and will encompass all of your assets, including your investment properties and businesses. Your will is a portion of your greater estate plan and should detail your exact wishes to a T. The more specific you are, the less your kids will have to worry about. Now, name beneficiaries. Anytime you open up a financial account, you have the opportunity to name a beneficiary. This is the person that will receive the funds when you pass away. Naming the beneficiary is essential, and it can save your family unnecessary stress. One thing you have to look at, how do you want to set your family up for a better financial future? What steps are you going to take to get them there? If you follow this path and take a holistic approach to pass down wealth, providing your heirs with everything they need to succeed, in addition to the money itself, you and those you leave behind will be far better served. They will then know how to build their own wealth and to keep it. This is how you become a rule number one family. Now, we're talking about that trust, the legalese. What is a trust? A trust is a contract between the grantor, which is the person who is writing the trust. You can call that person the grantor. You can call him the settlor. And you also, there are three components in a trust. You have the grantor, you have the trustee, and you have the beneficiary who's going to be benefiting from the trust. And that trust literally is your rule book. And if you don't, you follow the state rules, which it will then go, i.e. under intestate, meaning you died without a will, or testate if you actually did a notarial will or an holographic will. So you have to remember trust, and I've done trust before, and I mean, some of them have been 35 pages long, and you say, wow, the average person that sits down and do a trust, they don't have the time to read all that documentation, but I will suggest take it home, read over it before you sign on the dotted line. Know what you are signing. And there are different types of trusts. You have a testamentarian trust, which takes effect at death. This is created in a will, and it does not exist during your lifetime. And this requires a probate proceeding because there is a will involved. Or you have a living trust. This exists during the person's lifetime, and it shifts control in the earliest way possible upon disability or death. A living trust avoids probate if the property is funded. And the living trust is either revocable or it could be an irrevocable trust, which must be stated in the trust documents. Now, how do we go about, let me go back through to tell you the difference between the different persons. You have the grantor, in which I said is also the settler. That's the person who is coming to the attorney to say, I now want to transfer all of my property. I'm getting everything out of my name. And I'm going to put it, i.e., in the trust. You can have a family trust. You can have a pet trust, because I know a lot of people love their pets. So you can leave stuff for the pet to make sure someone is going to take care of him. You're going to transfer all of that property to a trustee. The trustee is going to be that individual who is going to manage and administer all of your property. For whom? That named beneficiary. Now, the difference is that same settlor who is creating this trust, he can also be the trustee, or he can be the named beneficiary. Case in point, a good example, O.J. Simpson. When they were trying to come after all of his assets, his lawyers set him up very nicely. No one could touch his assets because it was not in his name. He turned everything over to the trustee. So he owned nothing. So that's the difference. Now, I've seen people that have done trust, and the only thing that they put into the trust was a truck, the car, the house, and a boat. Was that necessary? Husband and wife, they paid $3,500 a piece. That's $7,000 from some lawyers from Texas that came down to, I think it was at a church here in town. And they bought it to me, and I was like, you're kidding me. All you should have done was do a simple will. Because when one died, the other could not do a thing, because you have to wait until the other person dies. So you have to think about, is it necessary for me? Do I really own that? Because trusts are for people that have money. And I'm not going to say how much money, but it's for wealthy people. Now, when you're doing a revocable trust, the basics it's mainly for probate avoidance. And it shifts control in the easiest way possible upon death. There are no court proceedings, and you can provide asset protections to your loved ones after your death. You cannot provide asset protections during your life because this is a revocable living trust. Now, an irrevocable living trust, that's created while you're living. And again, it's mostly for wealthy individuals. It gives asset protection to you during your life and your loved ones after death. Nursing home, lawsuit, creditors. And this is one thing we have no idea, because no one literally comes and tell us anything, especially with our parents. If our parents are elderly and we're putting them in a nursing home and they have a beautiful home, they have assets, the nursing home is not going to tell you anything. They're going to say, yes, bring them in. Whatever your insurance is going to pay, whatever insurance they have, Medicaid, Medicare, we'll take that. The moment they close their eyes, you will get a letter within a 10 to 20 day period saying your parents owe the balance of this. This is how much you owed. They're going to come after that property, that beautiful home that your parents have. So the thing that most of us do not know is, before you start saying, let me take care of mom and put her here, or dad, someone, make sure any assets that they may have, they put it in a trust, because they're no longer the owner. They can transfer it, because they are the settler. They can transfer it to a trustee for the benefit of themselves, or they too can be the trustee. So it's just how you formulate the trust document. But this is a lot of times we don't know this. And a client came to me recently, and boom, there's the letter based on their mother, and they owe quite a bit to the nursing home. And you can provide asset protections to you during your life with an irrevocable trust, living trust. Now, countable resources. What are these countable resources? Savings accounts, any banking accounts that you may have, investment accounts, certificate of deposits, stocks, bonds, mutual funds, and of course, your beautiful retirement accounts such as your RIA, your Roth accounts, your 401k, deferred payments, any real property that's not in your name, any inherited property, rented property, which is your investment property, any business property such as LLCs, corporations, any type of property. You want to remember, I need to do something with this. I don't want anyone to come after. If something happens to me and I have to go to a nursing home, if you have that trust in place, you're going to be fine. And I'm gonna put a pause right there. And because most people think I can do a power of attorney. If anything happens to me, I will allow someone to handle my affairs. Now, I will always tell my clients, think before you do such, because before the word attorney, there's a big word that comes before that, power. You are giving that individual great power over you. Got something going on right now. The dad is still living. He's amongst the land of living. He had to go to a nursing home, literally. Now, they thought he had one foot in the grave and the other one was coming right behind it. Daughter died before him and then her husband. But before that occurred, daughter was power of attorney over her father's estate. She ended up selling the property to her two daughters. Dad had no idea that had occurred. So when he was leaving the nursing home, it was, where are you going? You can't come here. So now he's in a whole nother nursing home paying about $2,200 a month. Good thing he does have money. That's a good thing. Now, this is another good thing. That same power of attorney, when she died, guess what? That daughter went, because the bank knew her, the relationships, said, oh, we want to, she, calls on the phone. We're taking care of my dad's wishes, and he wants to go ahead on and pay for his burial expenses. The bank knew her, so they said, okay, I'll be there, but I'm gonna send my daughter because my legs, I'm unable to walk. So can you give me a bank check for $15,000? Well, guess what? The bank did it. And it paid for his daughter's funeral, not his own. So when I say you want to make people power of attorneys, your loved ones can hurt you the most, and not just loved ones. Let's go ahead and say, and I don't want to offend anyone, but it is true. Because we are doing so well in our station of life, we don't have time to take care of our parents. So we allow someone else to come in and be the sitter. And that person literally is in your parents' head or your loved one. Before you know it, they become the power of attorneys and you don't have any knowledge. And they have taken everything. And then you find out at death of your parent, they have nothing, because you've allowed someone else into their world to take over. It can also be a pastor. It could be the pastor, the preacher, the minister, and it also can be a lawyer. So you have to be careful when you allow yourself or your loved ones to give that beautiful title to an individual. It means a lot. Long-term care documents. You can have a living will, which is always good because most persons, if your loved one is sickly, you don't want to make the decisions. But if that person has a living will, they will say, do not resuscitate. I don't want this. So it's not left up to you, the person. And if you're going to have a doable power of attorney, And I've done some that's been very, very specific. Or you could do a general power of attorney, but be careful on who you would name. You can have a medical derivative, or you can have a healthcare power of attorney. And the nursing home rules in, you can have a named curator. And also make sure if your parents have been in the military, have their paperwork ready. Have all of the important documents in one space where you will not have to be hunting for anything at the very end. And these are the 8 power of attorney's mistakes that we don't think about. Failing to have a power of attorney. Appointing the wrong person to have all that power. Not being specific enough in your power of attorney, because people will just have a general power of attorney. Failure to maintain an alternative or a backup agent if something happens to the first one. 2 or more persons acting jointly on your power of attorney. That means you're giving 2 people that power. Either this person can make the decision or the second person. If they must do it jointly, you need to have it stated specifically in the power of attorney. Failure to appoint a guardianship or a curator. Not inquiring into the financial institution accounts. And what most people think, because the power of attorney is not going to tell them, they assume that the power of attorney still continues at death. No, it terminates at death. Everything shut down. That person has no more authority to do anything. But guess what? Some of them continue on doing. Because we have no way of knowing, we have no knowledge. And the first thing we're going to say, well, mom trusts them, dad trusts them, so I trust them too. Be careful. Building your generational wealth for financial success. Building your wealth to last for generations is no easy feat, but it is an admirable undertaking. After you have your own financial situation under control, safeguarding your family's future is the next step. Take the time to implement a wealth building strategy that works for your family. Not everyone wants to invest in real estate or build a business. So find something that works for you, not what Harry, Sue, or John is doing. What works for you is better for you, not what others are doing. Make sure that you pass down your financial know-how to your children. I cannot say that enough. And these are some of my little pearls of wisdom. Build your own table so your children won't have to ask a stranger for a spot at theirs. And my generational wealth planning, preparing your family for your wealth. Always remember, what is your purpose? Why do you want to pass this down to your daughter, your grandchild? What is your shared vision? These are the things where you have families coming together, where I generally would be the person and one other lawyer is generally with me. And we're taking them through the stages. So shared vision, we all are working together as a family because we all are trying to keep it together. You could give back to IE, your alma mater. For instance, Southern, we have people that leave big money to Southern and also the Law Center and maybe LSU because some have gone there. Make sure you do your trust. That's your family bank. That's going to be taking care of you because you've taken it away from yourself and put it in the hands of that beautiful trustee for your benefit if you're going to be named the named beneficiary. You can also have your children be named the beneficiary and have it separated to be able to say, pay for their educational needs or whatever else they may be doing in life. Building this generational wealth is a lifetime learning. And you see, I have in the middle, family meetings, not just one. You have to continuously meet and keep it up. Earlier, someone said family history. We all need to know our family history, who our relatives are, because at death, trust me, they are coming. Uncle John will know daddy had another child. Even grandmothers, the mother of your father, they know. Aunts, uncles, they don't say anything, but then they'll come and say, well, baby, yeah, that's your daddy child. Really? Or it would be, well, who's this child coming around? Of course, I used to tell my daddy all the time. And I mean, I won't say I'm cold-hearted, but I'm my mother's child. And I used to tell him, if you can't bring them up while you're amongst the land of living, why must I do it while you at death? And I would not do it. And I said, baby, you can sit in the back wherever you go, the program is done. But that's me. Other people can be just as giving and taking them in under their little wings. That takes time. Ethical will, make sure whoever's going to prepare your will, that lawyer is ethical. And a lot of people, when they're doing their wills, they don't have any knowledge, because I've had instances where the lawyer prepared the will. And one of the legatees, which is the person that's receiving something in the will, also signed the will. Everything. So guess what? That will fail. So the wishes and desires of that testator was not met, because then the will went under intestate. So every person that the testator did not want to leave anything, it went to them. So you have to be mindful when you go seeking legal representation. Make sure when you're going to speak with that lawyer, some of the things that you want, you could prepare your own letter of instructions. What is your mission or your governance? Always have visions, values, and remember your culture. Have your toolbox ready. Remember, you must have trust, be sincere, reliable, and competent. Be able to communicate openly, honest, and be transparent when you're meeting with your family members, letting your children know everything that you may have, but you know which children to speak to. Remember that thought too. What are your expectations? Be able to define them, share them, and clarify them. And again, when you're dealing with your families, your loved ones, remember keeping their relationship together, because that's what's going to help with this generational wealth planning, keeping everything in the family. That is the main goal. Now, here's the rules of money. Remember to pay yourself first. Learn how to invest if you have not already started. Don't be a hater of it. Give every dollar a job. Spend less than you earn. Have a plan and set goals. Don't be a slave to money. If you have it, don't flaunt it. Keep your finances organized. It's a game. Learn how it works. Always have an emergency fund. Why? Because all of these tornadoes, oh my God. And I know most people do not do this, but I know when I first moved here and started practicing, Judge Laverne always used to say, well, Luke Laverne back then, he would always say, always have 6 to a year emergency funds, because anything can happen. And I was like, okay. And I started doing that and just keep building. Always have an account somewhere off that you can't touch, that you're not going to run to. Always make money work for you. Learn how to make your money passively. Use it to solve problems in the world. Know how to risk it and leverage it. Don't use credit if you have cash, which is very hard for us. But if you have the cash, I prefer paying, because I hate paying creditors. It's not what you make, it's what you keep. And here's the difference between active money and passive money. If you are employed, that's your active money. You exchange your time and effort for income. You don't work, you do Not if you don't work, you don't get paid. If you're self-employed, you work for yourself, but you can take a 6-week holiday and your business keep going without you, depending on who you have working for you. Your passive money is big business and investment. That's your extra money. Make that passive money work for you. And if you are employed, that's your money. You take care of your expenses, but you still have your passive money working for you. Remember to invest your income streams. And what do I mean by that? Your earned income, that's income from working a job. Your profit income is income from buying and selling. Your interest income, income from lending money. Your residual income is when you continue to get paid after the work is done. Your dividend income is income from owning stock. Your rental income is income from renting a house. Your capital gains, assets increasing value. And your royalty income is income from others using your idea. And there's that big bag of money at the end. That's all yours. And here's another one of my great persons, Steve Harvey, and he says, a person has to remember that the road to success is always under construction. You have to get that through your head, and that is not an easy thing to do. So always remember, success is always under construction. You're always building, because that's what they do. And here's Madam Oprah. Oprah makes $350 million per year, 26 million per month, 6 million per week, 850,000 per day, that's 850,000 per day, 35,000 per hour, 600 per minute, and $10 per second. Now that's where we need to try to get to her. So, and remember, she grew up with no running water and no shoes. So the moral of her story is never give up on your dream, because anything and everything is possible. And I think that is the end of my presentation. Yep. Any questions?
We have quite a few, Attorney Reed.
Ooh. Ooh.
Madam First VP, can you read off the questions out of the chat?
Where are they?
Sure. Let's see. This is a fun one. Our sister Nishan says she's open to being a beneficiary to anyone who needs one. It's the sisterly thing to do.
That would be Rashana.
That was Nishan.
Oh, Nisha, okay.
That does sound like Rashana, though.
Yes, it does.
Okay, we have one from Madam President. I have one daughter, so is a trust the best way? Also, should my will state who should be responsible for her in the event of my untimely death?
Yes, if she is a minor, I would say yes, make sure you stipulate in the will. So she could actually, now, based on her revenue, if she is in that category where, because I don't know how old the child may be, you may want to do that. Case in point, and now both of them are very deceased. I actually have a copy of Whitney Houston's trust that she had for her daughter. And she had everything in certain lump sums. Granted, it was a lot of money for a young child, but you could do that. And you can also put in the trust to have someone, that trustee can help take care of all of her responsibilities. So I would suggest, yes, by all means, have someone that you want to take care of your child. Why? You'll be surprised, because if they know there's money to be received, guess what? All family members gonna want to take care of her.
Yeah, isn't that the truth? So here's a question. So power of attorney ends at death, and executor's power begins?
Power begins on the date that the individual has signed his or her name on the dotted line. But it ends at death.
So is executive power and a power of attorney two separate things, or are they one and the same?
There are two separate things. An executor takes place in a will. You name an executor, and if one executor is unable to serve, if they predecease the testator, then you can have a secondary one named. But there are two different things. Now, the difference is, even though you may name an executor in your will or even in a trust, we call that precatory. It's a desire. It's not a bequest. So whoever is going to open up that estate, they don't have to have that the attorney name to handle the affairs. And if that executor is unable to serve, i.e. for whatever reasons, he or she may be out of mind, out of sight, or they may be elderly or ill themselves, then you would have to come in and ask the court, can you be the administrator over this estate? Or the court may name an attorney to do so. I can say he or she now because we have so many different judges on the court now.
The last question we have, you will know who asked. Oh, well, wait, we have more questions coming. Well, this question here is, can they get a copy of their will that you mentioned earlier? So you know who asked that already. So we're just gonna move right along past that question. If there is a power of attorney, but no executor, who oversees the will? Well, the POA is over at death, right?
Yes, you're gonna have to name an executor in the will. 9 times out of 10, but if that person is predeceased, then you could ask to be the administrator of the estate. Now, there are different types of administration. You have a regular administrator over the estate, or you can have an independent administrator over the estate. The independent must have the consent of all heirs to state that, yes, you can independently handle the estate of the deceased person. You don't have to keep running back and forth to court versus a basic administrator. But if you're going to sell property, which means immovable property, you have to get the concurrence of the court to allow you to go ahead and do so, because there are other rules in order to sell immovable property in terms of, and you've probably seen it in the newspaper where people are posting they're about to sell the estate, immovable property belonging to the estate of so-and-so.
Okay, I see no other questions in the chat or on Facebook Live.
Okay, well, I thank y'all for having me today. I enjoyed it all.
Thank you for being with us.
Okay.
So everyone, it is now survey time. In order for us to continue to give you all events that we know you're going to love and get so much information from, we ask that you fill out the survey and give us your feedback, good, bad, the ugly, whatever it is. We need to know how you all feel about these events. We also want to share with you our donation link. In order for us to continue to give you all events, it does cost our committee funds. And so we are asking, doesn't matter how much, how large, how little, if you can share, please do so that we can continue to give you all events that will impact our community. And lastly, we want to share with you some upcoming events that we have within the coalition. We have events, the Black Girls Love to Read 2. That's going to be happening on Saturday, April 23rd with our education committee. Our health committee is going to be having events on the 26th of this month, taking control of the cluster. And we also have on the 27th, maintaining me, mind, body, and soul. So we ask that you all definitely come out and support the coalition as we continue to impact our community. And do we have any comments or anything, Madam President, Madam First VP, do we have any comments for our guests?
Well, all I can say is,
Sister Danielle, I just want to say thank you. I think this is a very important topic that we probably need to continue to talk about, because I don't think people really understand the magnitude especially in our community. So I'm looking forward to other great events, especially around wills and valuation and succession. Thank you, ladies, very much.
Well, I like to tell you, Madam President, I have already called on Attorney Reed and Attorney Lamont. They already know I put it in the works that they will be back with us, giving us some more information. Madam First VP.
Well, I'm excited about the event that we've had today. There was some information that was shared with our participants and myself that, I mean, was kind of jaw-dropping, especially the video on how the family lost the 400 acres. I mean, I would probably be devastated if something like that happened to my family. And it was really sad to watch and listen to. So, but I'm excited that we were able to bring this forth to our members and our guests. And, you know, hopefully we can continue this going into our next program year. So, and that's all I have for you, Danielle.
Well, thank you so much, everyone. Attorney Reed, those hours that you put in last night were definitely well received. We appreciate you. We definitely appreciate the information that you poured into our coalition, as well as into our committee and the community. And so if there's nothing else, thank you all and have a great rest of the day.